second consecutive week of CB workshops here, which is really wonderful to see. 5 years ago, we wouldn't be having a meeting like this. The S.L.A. didn't sit down with community boards to talk about it. And I think they really do deserve an applause for that. There's really been a culture change at S.L.A. starting at the top, and it's noticeable. About a year and a half ago, the S.L.A. realized that there was a problem in New York City with liquor license applications, particularly in Manhattan, and put together a task force that included elected officials, the borough president was among them, community boards, and other stakeholders to discuss the 500-foot rule and the liquor license application process. This resulted in a report on the 500-foot law, which is on their website, and really since then it's just been amazing. The S.L.A. has not hesitated to come around to community boards, community organizations, and town halls forums to talk about this. So from the Borough President's Office, we're just thrilled that they're here today. And I guess without further ado, I guess I should turn it over to Josh first.
I think you should introduce our folks from the, yes.
Well, can I introduce Chairman Boyle from the S.L.A.?
Oh, thank you.
I'll be very brief. These are the two individuals you want to listen to. Joshua Toast, the CEO of the organization, and Tom O'Connor, Deputy Commissioner of our Community Affairs and Legislative Affairs. These two individuals are down here almost all the time, as well as upstate New York, talking to communities about what the S.L.A. does. And as you heard, we have made some changes. We got a long ways to go, believe me. We haven't made all the changes we need to make. But one thing that I can speak of is the chairman of the board at the top level. We believe in what the community has to say. I come out front and I'll say that. I listen to what you have to say. It doesn't say that I don't listen to the industry as well. I listen to the political influence as well. I listen to what everybody, law enforcement, I had a meeting with them this afternoon. The more that we can take in as a board, the better decisions we can make. And that's all we're trying to accomplish. But with that, we are going to follow the law. It's important. The law was written for a reason. Until it's changed, this agency, under my direction, will follow the law and adhere to the law. But it's very, very important to understand what people feel, especially in this city, of what they want in their community. And we're here for you. We're going to listen to you. It helps me to come and listen to what even my staff has to say. I learn each and every time they speak about this agency. So I applaud them for their efforts. I thank you for allowing us to come in to listen to what you have to say and give us some possible answer to some of the questions that you do have. So with that, I'll turn it over back to Brad. Thank you.
Thank you. So Richard's going to introduce our speakers tonight, and then we're going to begin with an overall assessment and explanation of how the S.L.A. does its business.
Well, actually, Mr. Boyle already said their names, but let me just go again. I guess we're going to be starting with Joshua Tellis, and Joshua is the Chief Executive Officer, is that correct, of the New York State Liquor Authority, and Tom O'Connor, who is the Deputy Commissioner for Government Affairs. So I'm just going to turn it over to you. We'll start. But I do want to say real quickly that we're going to have the process of this. We have an agenda in case anybody wants a copy of the agenda. We're going to start with letting them talk through, give their information and share with you. We're going to try to focus on certain issues down the road, and then we'll try to open up to questions and answers at the very end. But if there's a pertinent question in the middle, feel free to raise your hand. We're not going to. This is a workshop. So, go ahead.
Thank you. Thank you very much. Good evening.
Good evening.
It's great to be here. I try not to give a big speech because really I'm here to answer your questions. So I'll just give you a real quick overview of the State Liquor Authority, what we look like, how we're administered, and then really get into more of your agenda. First of all, the head of our agency, the chairman, is both the chairman of the board. For those of you who don't know, the State Liquor Authority is kind of a weird agency. It's an authority by name. It's run by a 3-member board. The members are commissioners, headed by the chairman. The chairman is both a member of the board who actually votes on all the applications, the licenses, the disciplinary matters, and also directs the operations of the agency, the Division of Alcohol and Beverage Control. As a CEO, my responsibility is to the chairman to run the day-to-day operations of the Division of Alcohol and Beverage Control. With that, we have a senior staff. Many of the people are new now. That we've kind of reshuffled the agency in the past 2 years, recognizing some of the concerns that communities across the state had. We did some staff reshuffling. So we have a licensing division, which for the community board people, you're contacting our licensing division all the time, sending us letters about proposed applications, proposed premises. The director of our licensing operation is Carrie O'Brien. So for those of you who regularly correspond with us, that's a change. Carrie O'Brien, she's director of licensing operations. She's out of our Albany office. And that information can be found on our website, which is www.sla.state. Did I mess it up on?
Yeah, ABC.
ABC. www. You know, we took the whole summer off. Community boards weren't asking us to come, so this is my first time back after my summer break. www.abc.state.ny.us. abc.state.ny.us. So Carrie's information can be found on there. Our director of enforcement is Dan Millay. So if you have any enforcement problems, you can always contact Dan Millay directly. You can contact me directly. My phone number is on the board right there. I'll give you my email address also. jtoas, Jtoas, @abc.state.ny.us. jtoas@abc.state.ny.us. That's my direct email. No one screens it for me, so if you send me something, I'll get it. The responses will be from me. Tom O'Connor is another person you can reach at that same number. So if you're having a problem getting in touch with anyone at the S.L.A. or you forget that I mentioned Carrie or Dan, call Tom or I anytime. Send us an email. We get them in the middle of the night. It's okay. Tom's email is the same as mine, except it's T. O'Connor. Is there a
No apostrophe.
T. O'Connor @abc.state.ny.us. So email us anytime. And basically, we can get the information you're providing to us to the right source in our agency. So if you're sending us information about a licensing matter, an application, a place you don't want to see licensed, you can send it to us. Or if you have a problem with a premise that's too noisy or underage drinking or whatever the problem, quality of life concerns, you can send that to us and we'll make sure we'll start an investigation. A quick step-by-step review of how we make decisions. The members of the authority are pretty much make most of the licensing decisions in the agency, and then they make all of the disciplinary decisions in the agency. There are some applications that the members have given us the responsibility to act on, but for your purposes, under what we'll talk about as the 500-foot rule, if there is any community opposition to an application, the members of the authority have not delegated the authority to me as a head of staff to act on that license. It must go to the members of the authority. So anytime you object to an application being approved, the members have to actually act on that. And if the 500-foot rule applies, then they have to affirmatively establish that it's in the public interest to issue that license. So I don't even get the opportunity to rule on it. We compile all the information and create a file for a particular premise, and it goes to the members of the authority. And I can guarantee you the chairman sits at his desk almost most days, especially the week prior to a meeting, and they meet every other week, doing nothing but hanging through stacks of paper like this with all the files for applications. So they really, really go through it. Your comments really matter. I can tell you that we've changed a lot of our decision-making process because of community boards and because of the people here in your community. Enforcement matters. Any complaint that comes in goes to our enforcement bureau. Police referrals go straight to our attorneys who review it, because sometimes they can file charges without any further investigation. Complaints will come into me, and I'll initiate an investigation. All investigations are handled by the staff. The members will not even be told of a particular premise for the most part, until the discipline is there. And after an investigation is completed, it goes through a hearing process, at which point, after the hearing process is concluded, it goes to the members of the authority who ultimately make the decision with regard to discipline. That's a real quick overview of the general operations of the agency, and I think you'll get a lot more of an idea of how we do things in the course of the agenda that's been presented. So I don't know if you want to go right into the agenda, or if you want to do, how you want to, just go down the list?
I think we should start down the list.
Okay.
Does everybody have an agenda? Anybody need an agenda?
I'll read them off as I'm doing it, if that helps. So,
I could use a copy.
Bob,
We'll get one for you.
So infrastructure, individual roles and responsibilities, I think I generally did that. The infrastructure is that the members have all the decision-making authority. They've delegated some of that authority down to the staff, and the staff will process all the applications, all the investigations, and then submit it to the members of the authority for their ultimate decision. We're a little different than most state agencies that have, one person in charge of the agency and then everyone else is staff. Here we actually have 3 members who have to act as a majority in order to make a decision. And as an FYI, right now we actually only have 2 members, Chairman Boyle and Commissioner Healy. We have a vacancy. So, process, step-by-step review for decision making. I think that's easier to go through as we're talking about some of this other stuff. So, the process for new on-premises license. Does everyone know what an on-premises license is? No? Okay.
Let's make sure everyone does.
An on-premises license is the legal term of art used for any license or any establishment which serves alcoholic beverages to be consumed inside. So it's a retail sale to a consumer, and the consumer is going to drink it where they buy it. Off-premises is just the opposite. So a package store or liquor store is an off-premise establishment where someone can't drink it inside. They have to leave, go home, or go out into the corner or wherever and drink it there. Okay? So that's the difference between on-premise and off-premise. On-premises would include restaurants, tavern, bars, nightclubs, cabarets. Am I missing anything? That's pretty much it. Under our laws, there's actually a distinction between types of on-premises applications. Not to get into too much detail, in the past, the authority has kind of commingled all the different things. So when you go into a restaurant now, the license you see will be the exact same thing as if you were going into a nightclub. The nightclub license and the restaurant license look identical. We're in the process of changing that. So in the future, you'll be able to go into a bar or nightclub and actually see on the certificate what type of license, what type of establishment they're supposed to be. In other words, if they say they're going to be a restaurant, they better be a restaurant. Okay? They'll say the method of operation, which will include the hours of operation, whether or not there'll be music involved, whether it's live music, DJ, band, all that type of stuff. We're going to put as much as we possibly can fit, depending on the computers and how well they'll print, on the actual application, on the certificate, the license certificate. So when you go into some place, or when law enforcement goes in, or when our investigators go in, you'll see exactly how they're supposed to be run. So, yes, sir.
Is hotel separate?
Hotel liquor is also an on-premises application. Some hotels will have on-premises establishments inside the hotel. That's distinct from the hotel liquor license. While others will have a restaurant or two inside the hotel, which is actually part of the hotel liquor. So it's always important to know, at least from our perspective, what the license actually is and what the premises are, so you know what rules apply.
So, you're going to distinguish between a lounge and a restaurant and the licensing?
We're going to attempt to distinguish between the left. Here's the problem we're facing. It's one of the reasons why we've been trying to do this for a number of months now. One of the problems we're facing is in the law, there's really no distinction between these things. There are a lot of restaurants, which everyone would agree are restaurants, that at 10 o'clock at night become nightclubs. And it's hard for us to distinguish on a license what to call that. We're thinking mixed use would be the best way to call it, the best thing to call it. But a lounge would be a smaller establishment without a lot of dancing, without live music. It would be more of what maybe a more modern tavern.
No kitchen.
Well, it depends on the type of license. Under Section 64, there's 2 different sections that primarily deal with on-premises. Section 64 and Section 64A of the ABC law. Those establishments licensed under Section 64 have to have a full kitchen with a chef. Those under 64A do not. They all have a food requirement, though. Everybody who has an on-premises license, I believe everybody who has an on-premises license in the state, must serve some type of food.
Is that? No, I understood that was changed some years ago. That because I've been to many bars that do not have any food.
Yeah, they're probably not doing what they're supposed to do.
Well, that's interesting.
But I'll double check that.
Hi. An establishment opened next to me, and they call themselves a dinner theater. They originally applied for their license as a dinner theater.
Right.
And now they're just by my definition, a raucous nightclub.
Okay. Well,
So, how do we define that, and are they within their...
You define it as scofflaw activity. I mean, they're potentially violating the rules. when someone submits an application to us, as part of their application, they have to do a couple of things. It's a 23-page application. But most importantly, I think most importantly for all of you, is what the actual premises is. And I'm not using a plural. That's actually, it's a premises with an S on the end. And a method of operation.
Well,
So,
how does one determine that? How do you determine that?
well, we know what the application says.
But do I call you and
Okay,
say,
I'm gonna have to stop because this is, we can't go on for every individual on this.
I will generally get into that. I promise you, because it's actually on here, method of operation. I will definitely address that because it's an important issue. Just to be more general about the licensing process. So, for on-premises establishments, there's two basic rules. Well, there's one basic rule, and either applies or it doesn't. The 500-foot rule. Okay? When it applies, there's a standard that we have to look at in order to issue a license. And when it doesn't apply, the standard's drastically different. So when the 500-foot rule, and I'll tell you what it is, does not apply. So it's a normal circumstance. The 500-foot rule does not apply, and it's an on-premises license. The members of the authority, when reviewing the application, and are there any lawyers in the room? Hey, I've been to these things where I'm the only lawyer in the room, so. The standard of review is that if the application meets the minimum qualifications, the license must be approved. Must be approved unless good cause is shown not to approve the license. And the courts have issued a lot of rulings on what good cause is. And community opposition alone is not good cause, at least not in Manhattan. So understand, when the 500-foot rule doesn't apply, when an applicant meets the minimum standards for applying for a liquor license, we have no real choice. It's very difficult to deny that license in those circumstances. However, if the 500-foot rule applies, I'll tell you what it is. The 500-foot rule applies when an applicant is applying for a license, an on-premises license, and that proposed premises is within 500 feet of 3 or more existing on-premise establishments. So if I apply at 1 Main Street and there's 3 or more existing on-premises establishments within 500 feet of 1 Main Street, the 500-foot rule applies. And the 500 well, it's measured from basically from front door to front door.
Radius.
Straight line test. Straight line test.
In every direction.
Yeah. So from wherever it would be wherever that premise is, you have to make a measurement for each different location. Okay. So it's not a radius. It's not, well,
Take it straight.
it's
If the center's the front door, you have no choice but to make it.
it's not as I don't want to make it overly complicated. It's not as easy as it sounds, but it's not as complicated as I just made it. So it's 500 feet, and doesn't matter. The bottom line is, if someone thinks there's a 500-foot problem, we're not going to take your word for it. We're not going to take their word for it. We're going to measure it ourselves, or we're going to get someone certified, a surveyor, to actually measure it. So don't waste your time going out measuring places, because I'll tell you, they're usually not right. Yes?
But the straight line can go, like, let's say that's the front door, it can go straight through to the block behind, let's say.
It's on the same street.
Okay, on the same street.
Simple question.
Yes, ma'am.
500-foot rule is it's left to right and right to left, and not including anything on the diagonal?
No, it's on the diagonal.
It's on the diagonal
Yes.
as well?
Yes.
Thank you for the clarification.
But nothing around the corner?
I'll have to double check that, and I'll get back to Brad on that.
Does the applicant have to give information?
I'm sorry, sir. By around the corner.
Like 200 feet one way and then it turns a corner 200 feet
Well,
the
if it's
other
a
way.
corner location, we
No,
consider it. If it's a completely different street,
Yeah.
for the 500-foot rule, can we check that real quick? It's in there. I'll give you an answer for you in a couple minutes. The big important thing about the 500-foot rule, believe it or not, is not the 500 feet. Because like I said, we'll measure that. The big important thing is that the standard of review changes. So it goes from we basically have to issue the license, to being in a circumstance where there's an inference that we shouldn't issue the license unless the members make an affirmative determination that it's in the public's interest to issue the license. So that's a big, for those lawyers here, you understand it's a different shift. The inference in the first instance is to issue the license, and the inference in the second instance is to deny the license. And then, unless the members determine it's in the public interest. In the past, the former members of the authority, before Chairman Boyle and before Commissioner Healy, believed that economic development was in the public interest. And in some cases it is. In some cases it is. The courts have said, in many cases it's not. And in any event, it's not in and of itself a factor that the members will unilaterally make a decision based on. And in fact, in most 500-foot cases where there's been community opposition, in other words, the public has said it's not in our interest, I think over 65% of those cases, the members have denied the license. In the rest of the cases, there's either been some back and forth on community opposition where some people have said it is in our interest, and other times they've been approved. Yes, sir.
Does the applicant have to indicate how many licenses exist within 500 feet?
On the application,
On the application,
there is a 500-foot application.
Well, you often get conflicts because the community will come up with a figure that is not in the application by the applicant.
And when there is a conflict, we go out and measure.
Yeah. Now, should the community board also get an application that's identical with what they give the S.L.A.?
Yeah.
Should it be comparable?
I think that the community board has an obligation to review as much information as it could possibly get. There is no requirement in the law that an applicant provide you with the same application that they provided us with. On the other hand, most applicants, especially in New York City, know that we're paying attention to what community boards have to say. So I think it's incumbent upon community boards to say to an applicant, give us the absolutely same application you've submitted to the S.L.A. The problem, and it's just a small one, is they are required by law to provide 30 days notice to you before they even have to give us an application. So we often will get a community board objection to a proposal before we've gotten their application. So sometimes you might ask for the complete application and it's not prepared yet. What you really need is what the premises is, the diagram of the premise, and the method of operation. The most important part that you can get is the method of operation, because that's where the compromise is. You might find that there's bars that want to open up, or a nightclub, or a restaurant that wants to open up, and you're okay with the location, but it's what they're going to do with the location that you might have a problem with. And I think you'll see that people are willing to compromise. And what we've learned in other community boards and in this community board is that there's compromise that happens. And there's stipulations that are entered into. And in the past, the stipulations were somewhat disregarded by the State Liquor Authority. We have a procedure now where we can incorporate those stipulations into the actual method of operation. And the members can impose it as a condition on the license. So that those stipulations, those agreements you make in good faith with an applicant, we can hold them to. And if they don't do it, we bring charges for method of operation, I will get into that.
Yeah, but if you don't send the same information available to the community board, how can they make a judgment against the information that's given to the S.L.A.? Shouldn't they be on the same playing field?
That's a real problem. We've had this.
Huh?
Yeah, we've actually
What
had
I'm telling you, there is nothing under the law which mandates that they do this to you.
Can't the S.L.A. commissioners and tell them to make it?
Can't do it.
Well, I've been in the meetings when they have done that.
We can only issue conditions on an applicant on a case-by-case basis. The courts have said we cannot do the type of thing you're asking us to do, and we're not a general rulemaking agency. We proposed legislation this year. It's pending in both houses of the state legislature.
The community board is part of the law. It's part of the law. It's in the law.
So there is no requirement.
Shouldn't we have information?
I understand that. You absolutely should, and there's a way for you to get it. All you need to do is ask. And if they don't give it to you, you know what I think you should do? Turn down the license. And I tell all the bar owners I see, when a community board, and I said it at our task force, and the chairman said it, and everyone in our agency has said it now, that if they don't give you information so you can make it, the members of the authority have actually sent me back to community boards, because we get like certain boilerplate language, and said, the chairman has said to me, Joshua, go talk to this community board, because the information they're providing us, it's too boilerplate, it's not enough. Okay, so I've said to all of you, and well, not yet, but I'm about to say it, is you have an obligation to get as much information as possible, but you can't require that they give something to you. What you can do is hold it over their heads that you're going to deny this application. Frankly, I think it should be a requirement. We've advocated for it. We think we should be a general rulemaking agency. We're not. If we were, we could snap our fingers and make it happen. So I agree. So there has to be compromise. The key is communication. The key is things like this. And usually, are there any nightclub or bar owners or restaurateurs here? Okay, so the key is usually is a bit more. The key is communication. And if you tell someone who's investing a lot of money into your community to open up a business that there's certain things that, and you want to have a communication with them, they're fools if they don't do it.
Joshua, we have a couple more questions.
Yeah, sorry.
We can start with Brad.
Would you recommend that community boards, in order to determine whether they need to weigh in on the public interest, conduct their own 500-foot examination? And what do you do with that information if they do?
I think what you should do, if I were in your shoes, what I would do is the first thing I'd make sure I get as much information as possible from the applicant. Method of operation. I'd come up with a standard list of questions to ask them so that you don't miss anything, and so that you get as much information as possible. And I would sit down with them. I'd have a meeting. Now, whether you did it at your committee meeting or whether you did it as a full community board, that would be up to you. But I would appoint someone on a case-by-case basis to open up a dialogue and find out exactly what they're doing. I don't know that you want to have an official 500-foot hearing. I think that's what that is. A 500-foot hearing is just nothing but a fact-finding to try to determine whether or not what the proposal is, whether that fits within the community, is it in the public's interest to have it. You can do all that by sitting at a table with the applicant, and that's what I would do. Personally, I think the 500-foot rule, if the members of the authority and the staff of the State Liquor Authority are doing their job, the 500-foot rule becomes, the 500-foot hearing becomes less relevant. The bottom line is, we have a determination to make, and you're part of that. However you get the information that works best for you is all that really matters.
Could you explain what those three establishments are that fall within, that trigger the 500-foot?
Any three on-premises license pre-existing. So if there's 3 restaurants in an area, or 2 restaurants and a nightclub, or a restaurant, a bar, and a nightclub, and a lounge, any on-premises place within 500 feet of the proposed premise, then it applies.
Not beer and
So
wine.
if there's confusion,
Not beer and wine.
if there's confusion at the community board level, whether the 500-foot rule actually is triggered, we should just proceed as if it were
No. I think, well, the information you give us, I think, should be the same either way. Okay? It should be the same either way. We want to know what you think about this proposal. So whatever rule we have to apply shouldn't be relevant on the front end. Where it should be relevant is on the back end. Because what is a frustration for me, and it's not so much a problem anymore, is that when you recommend, the community board recommends that we deny a license, and the 500-foot rule doesn't apply. So we're almost forced to issue the license, and then you get mad at us. It's the law. And the problem is that we've done everything we could to enforce the 500-foot rule strictly and in accordance with the law, but when it doesn't apply, it doesn't apply. And we get sued all the time. Not that I'm afraid of getting sued, but that's what happens.
Joshua, Zella Jones has a question.
Hi, Zella.
Yes, hi. We have an increasing number of instances where an applicant will come before us in preparation to have a full application with you when there is not a signature on a lease. There are no official documents as to the building. And they do not purport to have a final plan because, of course, they don't have a final building plan. And what they're trying to do is secure financing on the basis of having a license before they've done anything materially. The difficulty here is that we find, and there are absolute experiences, where this application changes radically from what the community board is presented and what an applicant may, in all good faith, think they're going to do.
Okay.
And then what actually does occur, so that spaces change, occupancy changes, and exits and entrances change, things that really materially belong in the consideration of the community, and now it's too late.
Okay. Well, it's not too late.
Okay.
And you raised a bunch of issues, so I'm going to try. Does anyone mind if I take my jacket off?
No, we do over here.
Take it off, man. Take it off.
When the boss wants to adjust, the boss gets to adjust.
You're right, those things were happening in the past. What this board does now is if we feel that something wasn't told to you based on the information presented to us, based on what you've told us, we'll either send them back to the community board, as Joshua stated, to get that rectified, or they might not get a license. They know that now. Every lawyer and representative that appears in front of this board knows they have to do their homework now. And they know they can't fool us. I mean, they might get past us sometime. But they realize now we're asking those same questions that you're asking. So we want to make sure everybody's on the same page.
It behooves us, for instance, in our resolutions then, if we receive an application that says occupancy will be 35 people, there will be 5 benches and 25 dinner tables, and there will be a rear exit into an approved rear yard. We should spell those things out, because that's the only way you're going to know.
Absolutely.
What you've got is what we've reviewed.
There's about anywhere from 5 to 10 different sets of eyes that review almost every application that goes to the members. So if you say you believe the certificate of occupancy allows for 35 people, and they present a certificate of occupancy with 75 people, someone usually catches it. I mean, you know, look, people make mistakes, but what we've tried to do in the course of the past 2 years is to implement policies so that these things don't happen. We've tried to educate our staff to understand the concerns you have, and that when someone like a community board is saying, yeah, we're okay with this establishment as long as it's a restaurant, and as long as it closes at 11, and as long as all these things, because that's what you thought you were approving, and then the application comes in, and the method of operation is distinct from that, that's a problem. And our staff now know, wait, we can't approve that, here's a problem, and we try to kick it back. That's why I said you have to try to get as much information as possible on the front end. So what happens when you have places that were either approved with all these kind of crazy things happening before the chairman came on and without these new policies, or things that slip through, and you get into method of operation. Okay, the method of operation is probably the most important part as far as enforcement goes, from my perspective, of a liquor application. Okay, because that is where the applicant is supposed to say, this is what we're doing, this is how we're doing it, this is when we're doing it. Everything about how that place is going to be run needs to be in that method of operation. In the past, the method of operation would say, we're going to be a restaurant. Now, there's a lot more detail that needs to be part of it. In fact, I got an email today from a lawyer who represents a lot of people before the authority, and he asked me, he said, a couple of my clients have just been charged with violating their method of operation. How am I supposed to change the method of operation? I mean, think of it this way. You apply to do something with the State Liquor Authority, and you say, we're going to do the following things. We license you based on what you told us. Then you go and do something else. Your activities are not legal at this point.
Is that
okay?
basis for removal of license?
Well, it depends. And I'll get into enforcement a little bit. I will tell you, this is the 4th state agency I've been at. Chairman's been in law enforcement for 32 years. Tom's been at 4 different state agencies. We've been regulators for better or for worse, our entire professional lives. The State Liquor Authority has a tougher time of taking away problem premise license than probably any agency I'm aware of. The law, the ABC law, just doesn't even account for what to do for an imminent threat to public health and safety. And the court cases have really gone against us for many years, and that's changing now. But for many, many years, the courts put a lot of hurdles in dealing with bad bars and revocations. But we do have cases now that directly, in fact, Club Deep, I don't know if any of you are familiar with Club Deep. I think the case was just finalized today. They didn't tender their appeal. We non-renewed that license for violations of their method of operation. The court ruled that method of operation, that they were operating in a way that was inconsistent with their original application, and ruled in our favor. And now they are closed. And that was one of the more problem premises in the Community Board 5 area. And they're closed now because of method of operation problems and other problems that go along with it. Typically, if you have a place that says they're going to be a restaurant, winds up being a nightclub, they're also, not only are they having those method of operation problems, they're selling alcohol to minors, there's drugs, there's fights, there's a lot of noise, rowdiness, just general mayhem, and so there's usually a lot of reasons we can bring an enforcement action. It just takes a long time. We have 7 investigators for all 5 boroughs of the city, Nassau, Suffolk, and Westchester County. It wasn't a typo, 7 investigators. We have 35 investigators throughout the state. So It does take a while, but, sir, for that place that you think was supposed to be a dinner theater, or it says dinner theater, so you assume it is, you don't have to know the method of operation. All you need to do is call that number, send me an email, talk to Tom, tell us what the name of the place is, and we'll look into it.
Give me a home number.
You know, people used to tell me I was crazy for doing that.
Yeah, you are. We have
But-
several questions.
Yeah, however.
Starting, actually, if we can.
This young lady was asking, I've been talking to her for a while.
It
Okay.
has to do with an alteration. All right, on-premise license, the individual establishment applies for a sidewalk cafe, and it's granted.
Okay.
And then suddenly, they are serving alcohol in the sidewalk cafe, or on the, the pages of the sidewalk cafe. Do they not need a separate alteration liquor license?
You know what? You lost me. Just go through that one more time. I'm sorry. They have
I'll let S.L.A.
I'm sorry.
A premise has a full license.
They have a license inside. Okay.
They go for a sidewalk cafe license. They start serving liquor in the sidewalk cafe, but have not added a license.
They don't need another.
Okay. So okay.
Under what circumstances is that, or is that
Well,
not
it's
legal?
not a separate license. So let's understand our term. I mean, there's a city permitting process, which I believe you're all part of, with regard to whether or not the sidewalk cafe can exist in the first instance. As far as the liquor license goes, first of all, we won't issue a liquor license to any sidewalk cafe anywhere in the state unless the municipality has approved that for outdoor usage. That's number one. Number two, we don't give multiple licenses for one premise. So what we would do is allow them to extend their premise. They would apply for, they would basically amend their original application to expand their premises to include that outdoor area. But again, we would only approve that if the municipality is okay with that expanded use. At that point in time, we may issue a license, or we may not. I mean, if the community board says to us, look, we don't have a problem with this restaurant, but now if they're going to be serving alcohol at night with music and all sorts of stuff that happens out there, we have a problem with that. So it's an alteration of an existing premise, and the facts just, the bottom line is they should not be serving alcohol without that being part of their licensed premise. But here's the caveat with that. Beer. Let's put aside open container laws for a second. That if you buy a beer in a bar or restaurant, you can take that beer outside.
In a sidewalk license.
It doesn't have to be licensed anywhere, except for the fact that you have open container laws. So, if you have open container laws, then you can't take an open beer outside. If you don't have open container laws, then you can take an open beer outside, even if it's leaving the licensed premise. Distilled spirits, hard liquor, can't leave, has to stay inside. So if you've ever been to a place that says, do not cross beyond this point with alcohol, that's why. So if they're drinking spirits outside, that's not good. If they're serving anything in any area which is non-licensed, it's unlicensed activity, we'll bring charges. If we know about it.
Joshua, we've got a question over here. Can you state your name also? So we...
Juan El-Aralde. Thanks for taking, the host.
Have we met before?
I don't think so.
Okay.
Back to the 500-foot rule.
Okay.
That's
My
what it's
favorite
about
rule.
here. I kind of felt a bombshell 10 minutes ago when you asked Mr. O'Connor, well, how does this rule work? And I heard over here that maybe it was 500 feet along the same street. I think it's very important for the community to understand really what the 500 rule is. And just as an example, let me throw out a question.
Sure.
If there's a block and it's 150 feet to a side,
Yep.
can there be 3 bars on each side, 12 bars on that block?
Can there be?
Without, of course there can be, but I mean, there's some idea that the 500-foot rule is a radius. If there's 3 bars on one side of the block, 3 bars on the other side of the block, 3 bars on the other side of the block, and 3 bars on the fourth side of the block, it's 150 each side. There's 12 bars there. So unless a 13th application occurs, the 500-foot rule does not kick in?
No.
No, yes,
No.
yes or no?
Deep breaths for everybody. Right? The 500-foot rule always applied. The question, as I understood it, was if you go around the block. That was the question, and I don't know the answer to that, although Tom might have found it. And I don't know the answer because I don't do licensing. It's not what I do. Our agency knows the answer to that.
It's what the meeting's about. It's really important for us to
Well,
understand.
sir, I mean, with all due respect, the ABC law is really big, and I don't know every single aspect of it, but I will get you an answer and personally call you with that answer. But the answer to your question right now is this.
I'll give you a card.
I will personally call you. The answer to your question is, if there are, the law applies, the way you just described it, the 500-foot rule applies. The 13th doesn't matter, unless there's a grandfather clause applies. So if the bars pre-exist, I think it's November 1st, 1993, when the law was passed, then those bars are grandfathered in. So in your scenario, you would take each bar, the proposed premise, so that 13th bar which is being proposed, wherever that is, you would draw a straight line to every other bar and measure 500 feet from front door to front door.
Along a path of travel, or a straight line as the crow flies?
Which doesn't, by the way, which doesn't necessarily make sense, by the way, but that's the law.
Does someone want to use a blackboard? We do have chalk.
It's okay. Tom.
No, I know, I understand. Oh, I don't.
500. Thank you. It's a discussion. Thank you. 200.
Yeah, that's going to jump in the agenda.
You think that everyone's confused about the 500 and the 200-foot rule? Okay.
Everyone's confused about the 500.
In this, it's outlined of one it is and the other is for.
So the 200-foot rule?
Yes.
Okay. The 200-foot rule applies when the liquor authority, so with the 500-foot rule, the rule is if it's in the public interest to issue a license, then it can be issued, otherwise you must deny it. With the 200-foot rule, any proposed premise within 200 feet of a school or religious institution or a place that's exclusively used as a religious institution cannot be approved by the members, period. Even if the church or synagogue or mosque comes out and says, we want the bar next door. Doesn't matter, we can't approve it. Where you have problems here is, measurement aside, there's two problems. One is, what's exclusive use of a church, of a religious institution? We actually had the law changed this year to coincide with what the members have done via policy. And the second and I'll get into that. And the second issue, well, okay, let me go back. The first issue is what's exclusively used as a church. What's that?
The bona fides of the church.
I'm sorry?
This is the bona fides issue?
Yeah, basically. Yeah, I mean, the law doesn't use that term, but it's exclusivity.
What about if you have to cross the street?
Do you have the answer to that? It's in the thing. Cross the street, it applies.
Okay.
Around the corner, 200-foot rule does not apply.
Unless it's on a corner.
Unless it's on a corner, so it's on a corner, then you're considered to be on both streets. Cross the street matters. Okay? All right. Exclusive use of the church. The members of the authority have started as a policy to say that just because something is used in a not-for-profit fashion, or maybe there's a 12-step meeting, or a blood drive, or something like that going on in a religious institution, or homeless shelter, or something that's consistent with what a church or a synagogue or a religious institution would be doing, that is still exclusively a church and applied to 200-foot rule. And now, in the past year, that kind of policy change has been made permanent in statute, passed both houses of the legislature, signed by the governor. I don't know the chapter number, but it's law. And it doesn't matter which side of the street you're on. But 200-foot rule, if it's around the block, the 200-foot rule doesn't apply.
Well, while we're saying this, can we address schools as well? Because that's what we have on here is what constitutes schools and places of worship. So is there...
School's a school.
School's a school.
Preschool?
Preschool.
Daycare?
Yeah, see, there's
Public school,
every school.
Private school is a school. Public school is a school. Nursery school is a school.
Wait, nursery school is a school?
Yes.
If it's exclusive.
If it's a school.
Does it have to
I
be
mean,
accredited?
and now if
What do
you're...
you mean, if it's school?
Well, I mean, if you're saying it's...
You can put
I
up
am
with the
teaching
so
my children at home,
I'm not-
is that a school?
No.
No.
It's not a school.
Why not?
Homeschooling is not a school because it's not a school, it's a residence.
It can be a school and a residence. I mean,
It's
I
not
don't
a-
know.
All right,
But
but
a
let's-
school is
it's-
a place where children don't sleep at night. but they learn in the daytime, is that the definition?
I'll say one thing. I think you need to understand, the 200 foot and the 500 foot was written by the legislators. It's so vague, it's got everybody confused. What this agency's attempted to do, we had a task force this past fall, last year, to sit down with everybody we could to try to straighten out the 500 foot and 200 foot. We did, I think, an excellent job in trying to do that, but there's still some gray area and confusion. I know there's confusion on this gentleman's part. There's confusion on our part, too, because we have to dissect what the legislature left apart and try to put it together to make it whole. So it's very difficult for him to explain the different things you're trying to throw at him, when in fact those were never answered by the legislature. They just threw it out exclusively at school, exclusively at church, and we're trying to get answers to those as we speak as well.
And actually, thanks, Chairman. Tom just reminded me of something which I forget because we don't differentiate between them, and I really don't even like to say this publicly, but there's actually 3 or 4 different 500-foot rules. So here's the thing. It doesn't. The bottom line is the fact that there's 3 or 4 different 500-foot rules. Through our counsel's office, our counsel to the authority has rendered a legal opinion, which is binding, which says that we treat the 500-foot rules as if they're one rule. And there's some nuances there which matter on a case-by-case basis. So in your scenario of the 13 bars, we'd actually have to know the location, which rule applied, determine what type of different on-premises
The scenario is the 4th bar. If there is a bar, one on each side of a block, that's 150 square, what happens with the 4th bar on that block?
The 500-foot rule would apply.
So it's
It always applies. Will it kick in? Will you have
I'm not
to?
sure.
Will it kick in?
Like I said earlier.
Will the 4th bar have the burden of proof or whatever that it's in the public interest?
Yes.
On its application.
Yes.
Yes.
Joshua, we have a
Yes.
question.
And what I'm saying to you is in the past 18 months, probably 65 to 70% of those bars have not been able to establish that burden of proof, and their license has been denied.
Is that statistic
Hold on,
public?
please. Let's stop.
Yeah, I mean,
Wow.
it's
Okay,
it's
thank you.
65 to 70% of the applications which we've received, which have received community board opposition, on premises where the 500-foot rule applies, and I don't have the exact number, have been disapproved by the members of the authority. I think the issue that's still a problem for people, and this is what you need to recognize, what we're doing now is trying to solve a problem that hasn't happened yet into the future. The licenses that are already out there are out there. We can't take them back unless we have an enforcement action. Because we have to establish, no, it's a legitimate question. We have to establish that there's been some misconduct. The courts have rules, and I disagree with the court. There's a property right that attaches with regards to a liquor license. And I think the courts are wrong, but I'm not a judge, so I don't really get to say. So the courts have said there's a property right which attaches. People are entitled to due process, and the only way you can revoke someone's license, basically, is after a series of adjudicated offenses which establish a continuing pattern of misconduct which has been suffered or permitted by the applicant. So, an example, the NYPD could go into a bar and see a whole bunch of drugs, and that wouldn't be enough in and of itself for us to take that license away. It's a very, very difficult standard. It's very, very difficult. Believe me, we've taken more. I was just going through this. For those of you who aren't aware, you should go through our annual report. You can get it on our website. It has all of our statistics on enforcement. Okay? We have done, last year we did 24 summary suspensions. In the 10 years before that, we did a total, I believe, of 10. Last year we did about, between revocations, suspensions, and cancellations, we had nearly 1,000. Penalties went up by $1.5 million last year. So we're making an effort. It's moving forward. But you know, those that's why I said earlier, good licensing decisions result in less enforcement problems. Unfortunately, right now we have a lot of enforcement problems. So we have to deal with this and try to prevent future enforcement problems.
All right, Joy, Joshua, we've got a lot of questions. Let's start with the guy in the back, please. And your name?
How are you?
I can't hear you. Speak up.
Okay, I will. Since you mentioned the jacket, I'm sorry I have to keep my head in scarf on because I have a little bit of a cold and I have a sinus problem. So
Okay.
No problem.
I want to be more of a not burning than I already am.
Yeah.
What's your question, please?
I really do, because I've been fighting this fight for almost 10 years, and I'm the equivalent of a jailhouse lawyer. The only thing that I want to say, other than writing down the phone number, which I assume is to your office, the Office of Enforcement, from what I understand, is I would like to clarify the 500-foot rule. It's not vague at all, and since there has been a lot of confusion tonight, and I've beaten many of those lawyers that you mentioned that were exclusively in these kind of cases a few years ago, so that's why you haven't seen my case yet. And so far, you know, until we had the big kerfuffle on Kemmer Street, the area has been relatively quiet, relatively. But
Ask the
on
question.
to-
Yes,
on to 500
please ask the question.
The 500-foot rule, it's not a question, it's a clarification, and I would like to, if you don't mind, because it's an important issue. First of all, 500 feet apply as the crow flies, meaning in the radius. The 200 feet apply to the same street. That's as clear as it is. 500 feet and 3 or more. It doesn't have to be a fourth. 3 or more. That's what the law says. So if there are
All right.
three within 500
All right, thank you.
No, I'm not finished. Then the property.
No, I'm sorry.
The property
This
rights
is-
issue. No, I'm sorry. That's a very important issue.
You're out of order. You're out of order. I'm sorry. I'm going to have to stop you. We have another
We
question
don't
over
have
here.
to stop.
Yes,
Otherwise-
yes, you have to stop,
Excuse
please.
me. This is a discussion about the 500.
You're trying to tell these people
No, I would
about
like
this.
to clarify.
Ask a question. Santa, if there's a question, please ask it. Please ask it only for questions.
Take it as a question then.
Only for questions.
So why do you get off saying that there are...
I didn't hear what you said. No, let him ask. It's okay. It's okay. Listen, I'm Big Brother. He can ask.
take
It's
it.
okay.
He
Go
can
ahead.
take it.
What's your question?
You look like a tough enough guy. You can
The
handle it.
property rights issue is a special argument built by a certain lawyer, which you probably know by name, but it's not worth mentioning here. And it's a matter of, you are a licensing body. You have to assert your licensing authority. It's not an authority, it's an authority issue, it's not property rights. Otherwise, when I have a driver's license, I can say it's my property, it's not the state's to
Guess what?
take it or lease it.
Guess what? I agree with you.
So we have to assert that.
But, and believe me, we have. There's more people suing us today than ever before because we're asserting just that authority. So I don't disagree with you whatsoever. We need to take a stronger stance with regard to enforcement. Thankfully, the members of the authority have done just that. Our fines are up, our suspensions are up, our revocations are up, our cancellations are up, our bonds are up, our licensings are down as far as 500-foot rule cases. So we are doing that. Notwithstanding all that, it's still a property right, and you know how I know? Because the court says so. So you and I can disagree, and I mean we agree with each other, we can disagree with the courts, and we're going to keep working to convince the courts that they're wrong. Until that time comes, this is the standard we have to abide by. So I agree with you, and I appreciate what you had to say.
Thank you, Joshua. We have a question here.
Can I ask one question, I'll raise my hand later and ask the second. The question was on the 500-foot rule.
Right.
You said that if there are
Can you just
three...
give your name, please?
Oh, I'm sorry, Cormac Flynn.
Oh, okay.
There is if there are three or more,
Three or more existing
licenses. Now, what happens if on your same docket, say there are only 2, but you get 3 or 4 applications for the same block come on the same docket? Do you need to approve them all because there are only 2 existing right then?
Good question.
No one's ever asked. That's a great question. I've done a lot of these. That's a great question. No, I mean once a license is approved, it's approved. Now you have 3.
Then you have 3.
Then you have 3. Now, practically speaking, I'm not sure that situation has actually occurred.
It's about to.
Is it really? And you know what? If you can get that information to me, I mean, that's important to know. I'm not aware of that occurring. One of the things we're doing, understand that most of the law with relation to the ABC has been around since 1933. And much of it is out of date. And when it's been amended in a quick fashion, somewhat of a haphazard fashion. It has created some confusion in the law. And for a bunch of other reasons, the State Liquor Authority has historically had problems enforcing certain provisions of the law. Part of what we're trying to do is upgrade our computer technology. So what we don't have now is the ability to geomap everything. We're working on that technology right now so that we can geomap everything. So those situations will be literally right in front of the members as they sit at the board. But the rule applies as soon as that third is approved, and you can't approve 2 at the same time. I mean, the issue does come up with regard to off-premise establishments, particularly package stores. A similar issue comes up, and we deal with it.
All right, Joshua, we have a question with Joe Hamilton.
Yeah, I've got two quick questions. They're easy. Should we, in our community board resolutions, be pointing out to you that we think that the 500-foot rule, that the hearing needs to be had? Or do you know? Are you depending upon the applicant to tell you that there's more than, and that they need a 500-foot hearing?
I think that, well, I'd say the vast majority of the time we know, but you should still tell us.
So it should just be one of those whereas's in there.
The answer is yes. We depend on a lot of information that the applicant sends us. Just like most government bodies who do licensing have to assume that what we're being told is true. Unfortunately, we don't have the resources. In the past, the State Liquor Authority, every time someone applied for a license, would literally go to that premise and look at it first, do an inspection. We just don't have those resources now. So whatever information you have, because you're here, you live here,
yeah.
If you have that information, absolutely send it to us. Some community boards do it, and like I said, the measurements, sometimes they're just wrong. That's okay. We'll check. I mean, when someone raises a 500-foot issue that's not on the application, we send an investigator out to specifically measure it. Sometimes it is an issue, sometimes it's not.
Because we
usually the 200-foot rule.
We used to not put it in there because we were told that the S.L.A. did it automatically.
I can't tell you how many times it's
slipped
again,
through.
Well, it slipped through where people are advised, and I think it's actually good faith on the applicant's part. Sometimes the attorneys who will tell people, you know, with the 200-foot question, say no, you're not within 200 feet of a school or church. The members will have to determine whether it's exclusive use or not. So they check no. We have no idea there's a church right across the street. So if you know that stuff, absolutely. And that information usually gets to Tom and our licensing people, and we double check that stuff. So whatever information you think we wouldn't know or that you want us to know, absolutely put it in your resolutions.
Okay, well, we're going to take a couple more questions, and then we're going to get back to the agenda, please. Carter?
I had a question for you. You know, a lot of the discussion of the 500-foot rule and the notes from the S.L.A. task force is opinion of counsel to the authority.
Right.
Is there any way the community board can submit specific questions that we see on a regular basis to you, perhaps for clarification on a basis before we see situations that we...
Sure.
Okay, and then second question is, premise space, you know, under a grandfathered clause where premise is operating since 1993, is an expansion of a space, because we've seen this in one case, probably in others, change in use is accepted, but an expansion of a footprint, for example, if to take over another commercial businesses next door and other things like that, or go down the basement and places the specific, what is premise?
I will tell you that my answer might differ from our counsel's answer, and his answer matters more than mine. My answer would be that you can't do that because the other place is not grandfathered in. So I would think, without presenting it to the members of the authority, and I can't do that because it's not. There's legal reasons why I can't do that to the chairman, but I would think that they would not be grandfathered in. Now, I would have to see that case and have it actually presented and look at the facts. There may be a very good argument to grandfather in that's very legitimate. I don't know what that would be. And I think our counsel would feel the same way I did. We usually agree on stuff. So.
You had trouble hearing the question.
The question was, if there's a grandfather provision for the 500-foot rule, so the premise existed prior to 1993, and they want to expand the footprint of the premise, let's say by buying out the property next door, can they now amend their application? I think the answer is no. No one's ever raised that question with me before. It's a great question. And I said that, I'm sorry?
As well as the basement.
As well as the basement.
The basement's the same premise. Well, it's the same location. It's the same physical location. It might not be the same premise. So I think my answer would be different with regard to that. But I know you're looking for some more general answers to things like that. It's really very fact-specific.
Is grandfather the same owner since 93?
No.
No, just continuous license.
Continuous license. Now, and that, by the way, is a really big issue, whether or not something's continuously licensed.
500 foot. Hold on, we've got one more question. Sean Sweeney?
You're getting back to sidewalk cafes again.
Oh, I didn't see it.
Oh.
Good to see it.
There are 975 licensed sidewalk cafes in the city. There must be about a couple of thousand, basically illegal ones. So what happens? Two things. Some of them, they're just little benches and people bring out wine usually. But let's say a guy actually is operating a restaurant with an illegal sidewalk cafe and they're serving wine or drinks. Should we call up enforcement? Are they selling off-premise, basically?
Well, the easy answer is that the State Liquor Authority has jurisdiction to regulate the entire alcoholic beverage control law. And included within the alcoholic beverage control law are provisions related to unlicensed activity. Since this place is licensed, the activity is off premises but licensed, we would bring charges against them administratively. So you should definitely call us. That's the easy answer without getting too much into it. Call us. That's different, by the way, though, than a place that, let's say, we deny the license and they allow BYOB or they start serving anyway. That's purely unlicensed activity. And while I would argue that we have jurisdiction, that's great. We have no remedy because they don't have a license, so we can't fine them. We can't revoke their license. We can't suspend their license. We can ask the police to arrest them. We can ask the district attorney to bring charges. But that's about it. We still want to know about it because we'll send a cease and desist order, but if they ignore it, there's nothing we really can do.
All right, Joshua, we've got some question in the very back.
Yep.
State your name, please.
Michelle Campbell.
Hi, Michelle.
Speak up, please.
Okay, I'll try. Okay.
I'll come to you.
No,
Oh,
Joshua.
yeah.
We need to hear it also.
Okay.
If there's a religious organization and it occupies the ground floor of an apartment building, it still makes it a religious organization?
No.
No, it doesn't.
No.
It has
Build-
to be the whole church.
The building, yes.
They have to own it, right?
No, they don't have to own it. They don't have to own it, but they have to operate and control that entire premise, that entire structure, and it has to be used for their purposes. You know, I do understand that there are a lot of places that are opening up religious institutions in residential buildings or in middle floors of. I understand that's happening. The law just doesn't address that situation.
Well, we have the
You know, it's an interesting point because there's a proposal now to build affordable housing over public schools. So that could have an impact on.
Understand, I think the 200-foot rule is being used now for a different intent as opposed to the 500-foot rule than it was originally meant to. The original intent of the 200-foot rule, I think, was to prevent children and religious folks from being around the evils of alcohol. Now, the 200-foot rule is used as to create a buffer. No new bars, and that's fine. I mean, you know, the law, the rule's the rule. We apply it, but so understand that's why some of these things weren't. You just didn't think that a church would be in the middle of a residential building, and you didn't need to protect anybody from that. And that, so if you understand the reasons.
Okay, we have another question with Robin over here, please. Robin.
Hi, I'm Robin Goldberg. I actually would like clarification of two questions that were already.
A little louder, Robin.
Speak up.
I would like clarification of two questions that were already posed to you.
Okay.
The first one from S.L.A. about
What are the questions, Robin?
Requirements of the application in front of the S.L.A. Do they in fact need to show a certificate of occupancy for
Yes.
the space? Do they also?
Everyone hear that? Do they need a certificate of occupancy? Yes.
Do they
Unless
have
the building
to have
doesn't have one.
A signed lease?
They will not get. Okay. The question was, do they have to have a signed lease? The answer is the statute. The answer is yes.
Okay, and also, do they also have to present final drawings?
Yes.
Okay.
But they can have their license processed without those things. And in some circumstances, it won't be approved without them, but it will be processed without them. So when they notify you that they're going to do something, they don't need all those things. It's before actual approval. And with a certificate of occupancy, sometimes there will be a conditional approval, which means that the members realize, especially in New York City, getting a C of O can be very difficult. So that they will conditionally approve the license, meaning the license is approved, but they have to come forth with the certificate of occupancy before we actually give them their certificate.
Okay, but you know, David Reck has a point with this. Hold on a second.
Yeah, this is something that we've experienced in this community board. Buildings that were built before the certificate of occupancy don't have certificates of occupancy, and they're not required to get them unless they get a major renovation, in which
We
case
require
they
a letter
need
from the codes department.
a letter of no objection, yes.
Right.
Okay, great. Next is Doris, please.
Wait, I had a second.
Oh, I'm
Go
sorry.
ahead. Question about the 200-foot rule.
Yes, ma'am.
So, if the building that the premise is applying for the license is a corner building, and the entrance for the establishment is on one side of the street, but the religious building or school is around the corner on the other side.
So I just want
How
to.
do you apply the 200?
I want to make sure I have the fact scenario right. You have a corner building, and the bar is in the corner building.
It's in the.
The proposed bar.
The corner building.
But
the entrance is not on the corner. It's around the corner from a religious house of worship.
Depending on more specific things and the address and other factors, the answer is it depends.
Right.
And unfortunately, believe me, no one gets more frustrated than we do about the fact that it's not always clear, black and white. But in that circumstance, it would depend. There'd be a lot more facts we'd need. But I would say probably the law would apply.
And it's across the street from
Across the street, if it's across the street on the same block, it applies.
Okay, we've got a question with Doris.
Yeah,
Yes, ma'am.
we have a case now where the Christian Science Church on McDougal Street was a complete church for years, and it is now converting the upstairs part of a building to residential. It's still going to have a church on the first floor.
It's no longer exclusively used as a church. And even under the broad standard that the members have created, which is now law, I don't believe that would be exclusively used as a church.
So in other words, a bar could open up next door,
well,
presumably.
No, a bar could apply for a liquor license, and it wouldn't be disapproved as a matter of law. Depending on what other places are in location, the 500-foot rule may apply. And certainly I think a factor that the members would consider, although it wouldn't have as much weight, is the fact that there's a religious institution there. Remember, when you're under the 500-foot rule, there's factors that have to be weighed with regard to whether or not it's in the public interest. So things that matter more than the 200-foot rule might not matter as much as the 500-foot rule, but the members still consider that type of information. I mean, they try to weigh a whole bunch of stuff and come out with the best decision.
Okay, we have a question in the back.
Okay, as to the 200-foot ruling at the corner building, my name is S.L.A, and I'm the director of the Head Start program, China S.L.A.
Okay.
We are funded under City and Federal and Board of Education. Presently, there are a lot of establishments trying to get into opening a bar across the street from us, directly from us. We are located at 180. They plan to open at 177.
Yeah.
There's a tutorial school next to us at 173. Around the corner, there's a church. There are two entrances to that building. And how do you measure the 200-foot ruling? Is it from the borderline from the church door to the closest entrance to that corner building?
It's from the main entrance. It's from the main entrance, the entrance that's used, to the main entrance of the proposed premise.
Okay.
But, yeah, so that, I mean, it's from main entrance to main entrance.
Now, there are two entrances. One is the main entrance around the corner, and the proposed entrance is on.
We have been cognizant of the fact that many applicants are attempting to circumvent the 500-foot rule and the 200-foot rule by giving us a bad address or saying something's going to be something that it isn't.
Or relocating a door.
Or relocating a door. Okay?
That way.
So we're cognizant of that. We do what we can to protect against it. When the law applies, and it's hard for me, I mean, you can give me a million different scenarios of if it's this door versus this corner. The answer is going to be it depends on the facts. But we are aware that people try to abuse the situation.
My next question is this. Can they open another door by submitting a new blueprint, keeping the main entrance, and say there's 206 feet?
The simple answer is they can. The simple answer is yes, they can do that. The law says 200 feet. The law says from door to door, so they could do it. The question then becomes, so the 200-foot rule may not apply anymore, which means the members of the authority aren't required by law to disapprove the license. However, it's likely in Manhattan that the 500-foot rule still applies. And if it looks like an owner of a business, a proposed owner or applicant for a liquor license, is not acting in good faith, they're going to have problems with the members of the authority. They're going to have problems with the staff of the authority, and this community board is not going to recommend approval to someone who's already playing games with the system. So it's not just whether or not the 200-foot rule applies. It's getting all this information to us so that if you tell us ahead of time, these people are already acting in bad faith, we're going to look into that. The law still may require us to issue a license, but maybe it won't. We're going to try as best as we can to protect the quality of life concerns that you have.
Great, thank you. Maria Durr has a question,
Hi.
please.
What's the standard of review for a transfer? Because it's basically the same as another new operator. Is it the same as a new on-premise, or are there additional factors that you take into consideration?
Well, because the terms differ, and people use different things. By transfer, what do you mean?
I mean that there's a balance on the term of the prior liquor license, that the new owner can come in and take over.
Okay,
right?
okay.
Isn't that,
No. All right, that's why I asked, and I'm not... Yeah.
Isn't there the balance of the term on the
There's
license
two different
as
things.
required?
There's corporate change, and then there's what we refer to as a transfer, which really is a non-existent thing. A transfer license is a new license.
Oh, okay.
Okay, so if I'm Corporation A and Corporation B wants to buy my location, Corporation B has to apply for a liquor license at my premise and go through the whole approval process. If approved, then Corporation B is the new licensee. The license is not transferable. In the alternative, what could happen is Corporation B could, instead of buying Corporation A and making Corporation A part of Corporation B, the principals could buy out the principals of Corporation A, keep the same license, because remember, we license corporations, partnerships, and individuals. So if someone buys the corporation, they stand in the place, it's the corporation that has the license. They still are required by law to notify us. They're still required by law to give us information regarding the principals. We still fingerprint them and all sorts of stuff. But the standard for that is different because it's the same. It's already, that licensee is already there. The new, what you referred to as a transfer license, is the same as getting a new on-premises license. All of the rules apply, keeping in mind the grandfather clause and being continuously licensed in that much. Did that answer your question?
Do you look at that differently?
I'm sorry?
Do you look at that license differently than like a license in virgin space?
I'd like you to raise your hand for questions. I really would appreciate it, because we have 4 other people ahead of you.
Excuse me,
I also would like to have other people
I
in this
rescind my
meeting
question.
be heard, okay?
I rescind my question.
Okay, thank you. We
I'll tell you.
have one more question from you.
And then,
we want to hear from other people. Yes, I know. I see that.
Yes, sir.
You addressed a lot of what you
I got you.
would say we should do. Thank you.
I'm going to get you back.
Is there a way, thank you, is there a way that individuals, not going through the community board, can reach you to discuss the 500-foot rule?
Happens every day.
Right, because you've been addressing, no, but the community board has an advisory role.
Yeah.
Can individuals, separate from the community board, also influence you? And if they wish to influence you, because the community board doesn't always do what we say. If they wish to influence what's happening with application, how is it weighted?
That's his last question.
How do we phrase what we want to say?
It's a fair question. It's a fair question. So let me.
How much is the business owner? How much is the community board? How much is someone that approached you directly, and said, look, this is going to stink, there's too many bars?
Again, all these things are fact specific. But I'll tell you this. We will take information and input from anybody, whether it's another business, whether it's law enforcement, whether it's a community board, or whether it's just the average citizen. Anyone who wants to give us information, we review it. The community board in New York City has a special place because you stand in the place of city government. In every other municipality in the state, it's the city or the town or the village government which has the role you have. In New York City, you supplant the city council for our purposes. So the information you provide us is vitally important. The members have to get this information. And let's assume there's opposition and it's a license the members review. And they have to decide, weigh which witness, so to speak, gets their opinion, it has more value. And I would think oftentimes the community board has tremendous amount of value in their opinion. But there are times when it's not so, it depends. It's very fact specific. But we'll get information from anyone. Anyone is welcome. I mean, I feel like I didn't answer your question. It depends.
No, it was a good answer.
Okay.
It was a good answer.
I mean,
it was.
Arthur, my name is Arthur Kellman. I'm a relatively new member of the community board too. I'm on the business committee. I hope a yes/no answer to this question.
Okay.
My mind has been thinking about when these applications go in, and then there's various changes with 30 days. But there's a time that strikes me before the official review. Is that file open to the public? Could I, as a citizen, go to Albany, wherever the file is, and say, I'd like to see that application?
You wanted a yes or no answer.
I would like one. Possible.
Here's my answer. Yes, subject to the FOIL rules and personal privacy protections. So if you ask for the file, we'll give it to you. Certainly if you're a community board, we want you to have that information. We will redact information, the financial information, personal phone numbers, addresses, banking information, stuff like that. Criminal histories, we're not allowed to give you. But other than that, yes, absolutely. I mean, all of our documents are subject to the Freedom of Information law.
Okay, Keith, Berger?
Right. Renewals, are they automatic?
No.
How do you stop a renewal? Because
I go like this.
I can do it too.
Come on, my boss is here. You're putting the pressure on me. No, all right. We changed our renewal process dramatically. In the past, it was automatic. Not because anyone was trying to pull a fast one, but because it just so happens that probably the staff that does this is more efficient than anyone else in our agency, and they just get through them quick. So when they come in, it's a quicker review. That doesn't happen anymore. They're still very efficient at what they do, but we've put a lot of safeguards into things. So for instance, now, if there are pending disciplinary charges, or if there are pending investigations, mostly disciplinary charges, but if there's really investigations where the potential is for very bad things, we issue what's called a SAPA letter. SAPA is the State Administrative Procedure Act. As I said earlier, on the ABC law, we really have very limited resources, very limited ability to shut a bad place down. And under the law, just an allegation, just like anything else, just because you've been accused of a crime doesn't mean you're a criminal. You've got to be convicted first. There's a lot of people who are accused of bad conduct in our industry, but that haven't been actually convicted of that conduct yet. We can't we have to continue to allow them to operate. Otherwise, we're violating their due process. So we stop the renewal. We allow the place to continue to operate via this letter, which would be the equivalent of a license, but it doesn't have a term. And the letter stops being effective upon the adjudication of the disciplinary matter. So if it's adjudicated and it's really bad, their license will be non-renewed. If it's adjudicated and it's really a minor offense, not a big deal, their license at that point may be renewed. We also have just started, and we're actually rolling this out now, we're having non-renewal hearings now. So, and that's an extra safeguard for due process, so when we non-renew a license, oftentimes the courts overrule us. Now we actually have a due process hearing that's in place. We'll give the opportunity for them to be heard, and then someone on our staff will make a decision after that hearing, judge all the facts, and then non-renew it.
Hey, we'd like to know about those
Can the
hearings.
public attend that meeting?
Yeah, we'd like to know about
non-renewal hearing, I don't know, we haven't had them yet. So the answer is, generally hearings in front of a state agency or any agency are open to the public. A non-renewal hearing will probably be less exciting than a 500-foot rule hearing. It will literally be someone standing up and reciting facts, and that's it. And I would anticipate these things to be no longer than like a half an hour. I'm not sure it's something you'd want to go to. Having said that, I'd have to find out.
But is there room for community board input
so
in the
for non-renewals, there's absolutely room for community board input. Here's the thing with non-renewals. Like every other license, the applicant, whether it's an original application or renewal application, is required to submit to the local government, in your case, you, 30 days prior to submitting the application, notice that they're submitting the application. You've probably noticed in the past few months that a lot of renewal applicants have been coming to you, begging for, have you noticed that? Begging for, okay? That's because we started actually non-renewing licenses, and we started fining people for not providing notice. The notice period is your opportunity 30 days ahead of time to know someone's applying for a license and then to comment on it. And I'll tell you, for us, it's vitally important because I've learned of a lot of bad places that when I looked into our system, we had no pending investigations and no prior adverse history because no one ever reported it to us until the renewal came up. So it's very important. You have an opportunity, but understand this. The renewal is very time sensitive. An original application in New York City right now takes 5 months to process. So you have a little time. And the renewals, It's about a couple of weeks, so you really got to get on the ball and get us information as quickly as you can.
It's a very big time issue.
I'll be very.
We have a question behind you, Zella, real quick.
I'm sorry. Ellen Peterson Lewis. I have a question on the renewal. It's partially answered because someone else brought it up. But how does the community board know that there has been complaints lodged with the ABC concerning a renewal application?
You wouldn't unless you asked.
And so,
Is there any way to find it?
so should the community board
You should notify the
ask,
board.
because prior to the public hearing before the business committee, should they ask the ABC whether or not there have been any complaints lodged on any of these? Because you look at the list, there's like 30 renewals at one shot.
Many times, there are no complaints filed against the place that you might not be happy with. So it's always good if you have them, not to worry about whether we do, but just to get them to us. That's the first thing. Second thing is, anyone should always feel more than comfortable calling us up, and that's, you have a district manager who can call us up, or staff of the community board to call us up at any point in time and say, we have this location, do you have any adverse history against them? Absolutely. And people call Tom every day of the week.
Zella has no.
Yeah, New York City has a lot of new hotels
Yes, they do.
cropping up. The hotels are not showing up in what are generally considered commercial areas or shopping center areas as the original Patavan law addressed it. They're showing up in the middle of residential areas or on the sides of residential areas and in the middle of already very dense licensed areas of New York City. So we have an entire slew of applications coming down the pike from either hotels themselves, as you have described them, or following that, spaces that will be leased within a hotel, already existing in areas with 15, 20, 25 licenses within 500 feet. We can dicker about whether it's the radius or not. I'm not sure that there is an answer. I bring this up because I know it will be a problem.
It's an issue.
And we are going to need help in interpreting this in some fair way as far as the public interest is concerned. Weighing a business's need to be able to have a reasonable income, and it has evolved over time that a hotel's reasonable income might be entertainment that goes on in them. One of our problems is that most of the new hotels are entirely entertainment hotels, like those at South Beach in Miami, because they're the same developers. So we're going to reach a situation where we've got people who have towers of licenses and towers of entertainment in the middle of already dense areas, and knowing how to weigh the pros and cons and which public interest we need to look at is going to be very difficult.
Well, it's great. It's a great point. It's something I know we're going to struggle with as well, because there are a lot of competing interests. This is one of those cases where it's hard for me to speak for the members of the authority because the issue is a developing one. It's similar to the issue of the rezoning. And it's a tough one because I think on a policy level, it's what we kind of talk about to try to figure out. It's something we're aware of. I don't know what the answer is. I think part of it is going to be what type of hotel are we talking about, what size of hotel. And then there's the issue of, the great thing about what we can do, we can't generally make determinations that apply to everybody. But we can put conditions on a particular license. So, for instance, in a hotel liquor license, we could put a condition. This is a hotel liquor license. It's for one bar with one restaurant for your hotel and room service, and that's it. I mean, there are things we can do, but this is the developing policy. I don't know where the members are going to go with that yet. But, one of the things that's really helpful for me to do these meetings, because a new issue comes up, Tom and I go back, we bring it to the members, and we discuss it.
So this is something we can have an ongoing dialogue with you.
I hope we do.
As it develops.
Yeah, because this is not the only.
From the community
yes,
side.
It's not the only area in the city where this is an issue. In fact, it's not the only area of the state where it's an issue.
Okay, David Reck has a question.
Yeah, not only have I served on the community board, I've also served on the First Precinct Community Council, and there have been, this is some years back, there have been incidents where we've tried to argue on renewal and discovered that criminal acts that are on record here with the New York City Police never made it to the S.L.A. What is your current relationship with the police department?
I think as the chairman, we actually, right before here, we met with the assistant chief for Vice, the deputy chief for Vice, Brian Conroy. We meet with him on a regular basis. We meet on a very regular basis with the assistant chiefs, the deputy commissioners, basically 13 NYPD senior officials and us in a room talking about coordination. Our coordination is great right now. I think we are getting a lot more referrals than we ever have. We're coordinating more activities with the NYPD than we ever have. We have actually, our staff is working 2 to 3 days a week actually as part of NYPD task forces with regard to the march operations that they run, for those of you familiar with it, and then other activities which I'm not going to discuss here, but on a regular basis. So we have daily contact with the NYPD at all levels, and more importantly, it's not just our field investigators and the troops on the ground, so to speak. It's at a very senior level of our agency. The chairman has met with the police commissioner. I meet with the deputy chiefs all the time. Tom's there, our director of enforcement's there. It's a big deal to us. We've reached out to law enforcement all across the state to try to coordinate better.
It's a big deal to us, too, because we've had traditionally a very difficult time getting troublesome places closed down.
There's 2 things I would recommend. In an emergency, something bad's happened, call the police. If there's a continuing problem, you should call the police about noise and stuff like that. Call DEP, get a reading on noise, especially under the new noise regulations. But also call us. Don't assume on any given location that we're talking to the NYPD about it. I mean, we likely are, but understand with the spate of violence that goes on in upstate New York in the past 2 weeks, there's been 2 shootings in bars. There's been a couple, I think, in the last few days in the city. So we deal with the NYPD on all sorts of issues. For quality of life things, we definitely communicate with them, but they're tougher as an enforcement agency, they're tougher to deal with. Definitely, please, 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 if you have those types of problems in your community, call us directly, send me an email, call Tom. We'll have an investigator start something and look into it.
We've got, guys, we're running out of time. David Gruber, since you were so kind enough to put your hand
Yes,
up.
thank you. Because beer and wine does not come under the 500-foot rule or the 200-foot barrier, it's always been an assumption in this community board that kind of, it's rubber stamp.
Okay, restaurant wine does, the 200-foot rule applies.
Say it again.
Restaurant wine, 200-foot rule does apply.
To a church and school?
For restaurant wine licenses.
Right. Restaurant wine licenses, right. But
Okay.
for, really?
Yeah. I'll double check that, but yeah.
That's not been our experience.
Okay.
Because we have restaurants on top of churches.
Not the 500-foot rule, though.
No, okay. It's not been our experience that schools or churches have a 200-foot barrier for beer and wine.
Not on restaurant wine.
Not on restaurant, I'm wrong? I've been corrected.
Okay. So it's always been an assumption, at least in my mind, that those are kind of rubber stamp. But talking to Chairman Boyle earlier today, he says that beer and wine licenses are given the same rigorous review as full liquor licenses. And I'm wondering, do you have have you had a history of turning down beer and wine licenses that were inappropriate?
Yes.
So we should, as a community board, not assume that this is something that will automatically be approved.
Don't assume it, yes.
Okay.
I mean, yeah. The only issue is they all get a very vigorous review. The question is going to be, what is the legal standard that applies? But I'll tell you, many beer-only places are actually of greater concern to us from an enforcement standpoint than other places. Sales to minor are a big issue with bodegas, and there's a whole bunch of other issues, so it's a big deal.
All right, well, I'm going to take this one last question because it's a new voice, and then I need to go back to the agenda on some specific points.
I just wanted to make sure we covered the method of operation.
Okay.
Thank you.
The method of operation, again, is what a bar or a proposed bar tells us they're going to do. How they're going to run their bar, the hours of operation, what type of place it's going to be, restaurant, bar, nightclub, live dancing, DJ, music, what kind of music. Is it going to be a band? Is it going to be an occasional band? What kind of food they're going to serve, their menu, all sorts of stuff like that. You name it, that should be in their method of operation.
And that's
if someone...
that's posted in their license, it's on the window?
Part of their, no, it's not. But it's section H of the application is the method of operation. In the past, the method of operation has been, people haven't put much. We're trying to change that. We're asking a lot of questions. If you go to a full board meeting, and if you don't go, watch it on the internet now. Go to our website on full board days. Tomorrow's a full board day. Go to our website, I gave it to you earlier, and go to the webcasting, and you can watch the members grilling applicants. You can look at the lawyers in the room going, they start at 10 a.m. Every other Wednesday, abc.state.ny.us. So if the problem historically has been, you don't necessarily know what's in their method of operation, and they might tell you something and tell us something different, or they might tell us the same thing and do something differently. Okay. Which we would never know about until you complain about it, which you might not be able to complain because you don't know about it because you don't know what's in their method of operation. Right? Sound like fun? Okay. So here's what we're trying to do. It's a long process. A lot of it, you don't really care about this, but our computers just aren't able to do what we'd like to do right now. So we're working on a project that would change the face of our license certificate. And in the future, our license certificate will be color-coded, consistent with the type of actual premises it will be. Will it be a restaurant? It'll be a yellow application. I don't know if it'll really be yellow, but let's just say. If it's a nightclub, it'll be a purple application. If it's a tavern, it'll be a red certificate. And on it, it'll say hours of operation. You know, it'll say 12 till 10. You know, it'll say live dancing. It'll have as much of the method of operation that we can fit on the face of the certificate, which is only about that big.
Point of information, that was one of my questions. Where does this license have to be displayed? Does it have to be
conspicuously?
Conspicuously, but isn't that like a shade?
Where would I suggest it would be displayed?
Yeah.
I mean, if it's a bar, I would suggest it's right behind the bar. I mean,
Can it be in a person, in the person's office?
no.
Okay.
No. So if a method of so that will be there. So you can, if something's not consistent with that, then you can obviously file a complaint. If you're unsure, if you think a place has said they're going to be a restaurant, and they're not, call us up and say, you know, this place, I think they said they were going to be a restaurant. They told us they were going to be a restaurant. What's on their method of operation? We'll check. We'll do a method of operation investigation. And like I said earlier, we do those all the time now. They take a little longer than other investigations because there's usually not a public health and safety issue. But we do those all the time. Licenses have been non-renewed based on method of operation. Charges have been brought. I don't know the average fine, Chairman, for now method of operation, depending. No adverse history, $3,000, maybe $2,500 to $3,000. If there's adverse history and there's method of operation, then the fines go up, and if they keep doing it, you're talking a potential suspension or cancellation, and maybe even a revocation. And from the non-renewal standpoint, that's where we really can get people, especially for method of operation stuff, because we have case law now on our side. Is that
Yeah, I guess just before you color code this, is there something on the licenses
No.
now that deals with that?
No. On the license now, it'll basically say this is a license between section 64 or 64A or 64C or 64D. That won't mean anything to you. It really never meant anything to us either. So the best thing to do, if you're unsure, is call us up. Or even better for us, if you don't mind, email us. We'll look into it. We'll let you know whether we think there's a problem. We get community board emails every day about method of operation.
Okay, we have, first of all, I've got two quick direct questions that need to be asked here. Carter, you had one?
Who can enforce the ABC law or laws that you enforce, or other agencies empowered to enforce them?
Any police agency would enforce it. So in the city of New York, the NYPD and the State Liquor Authority.
Joe Hamilton?
What did I just say? Oh, do you use DBAs? I mean, when on these methods of operations, on the application process, on the computer links, are you using their DBAs or these corporate names?
Everything about a corporate entity, everything about a business has to actually be approved by us. So if someone's operating using DBA that they haven't told us about, that's a charge. They'll get fined for that. If we know about it. Again, that's why it's so important for you to tell us.
We know that these places buy these DBAs.
We know the corporate name. Right. So, if they're operating, if they change their name, you might want to call us and say that they get approval for that. If you see new people operating it, you might want to let us know because maybe it's an availing, which is like the death penalty offense in the ABC law. So anytime you see something different in a bar, and it's a bar that you have a problem with, you should definitely see, maybe they've applied, maybe they've done it the right way, maybe they've done it the wrong way.
Thank you. Joshua, as chair of this event, I would like to bring up, we've covered most of this agenda, but I do feel that there's one really important thing that we should go over on this agenda for the community board and for the business committee, which is really what are the key elements and factors in the community board resolutions that we should be working on. And anybody, anything just as
in the past,
defined as possible.
I'm going to tell you exactly what to say.
Pay attention, everybody.
Because I'm going to tell you what not to say. Don't be lawyers. Don't write stuff in ways that like lawyers. When I went to law school, they tried to teach us not to speak like lawyers. To teach like regular people. Okay, so forget all the whereases and heretofores and all that stuff. Tell us what you want us to know. Make it very clear that when you're recommending an approval for the license, that you're recommending an approval, not that you voted in favor of the resolution which recommends denial. It's just, understand? Okay? Tell us exactly what you're talking about. If you're recommending a disapproval, we recommend that you disapprove the license. If you've done what I said, I think it's a good thing for you to do, which is meet with the applicant, come to some consensus, and agreed it's okay to have this place at this location under the following circumstances. Make sure the applicant amends the method of operation to include the stipulations that you have gone over with. So whatever your agreement is needs to become a part of our method of operation. That way, you can say the following. We're the community board. We voted. We recommend that you disapprove the application unless the following stipulations have been incorporated into the method of operation of the proposed licensee, or the members of the authority impose them as conditions upon the license. And then let us know that you've actually met with the licensee, you've worked these out, and they've either agreed to them or disagreed to them. If they've agreed to them, they should become part of the method of operation. If they've disagreed to them, you can still ask us to impose them as conditions. The members will consider that. Whether they do or not is up to the members. But at least we know exactly what you're talking about. We know that when you in good faith met with them, and you were willing to consider a licensed premise at the location they want, but that you have some conditions because you want a quality of life that's good. So we just need to know that information. Yes,
okay,
sir?
where?
Do that on a renewal.
Yeah, you could do the same thing on a renewal. But with a renewal application, understand that their method has been in existence. Our ability to change that, understand, if it's a renewal with a place with adverse history, we're going to be more likely to try to not renew them. If it's a place that has no adverse history, why do you want to change? If you don't have a problem with it, let them do their business.
So I think we've come to our end here. Thank you so much. It's been extremely